Well, welcome back to the Slingshot and Happy New Year, everyone. Today's special guest is Zephyr Teachout, professor of law at Fordham University, who recently did a stint as a special advisor and senior counsel for economic justice at the New York Attorney General Office. Now, all that stuff you probably know, but what you don't know, unless you study her Wikipedia page, is that Zephyr, quote, did some acting in high school and at Yale. And now I want to know if she's got any of these VHS tapes from those 90s performances. For the record, my VHS tapes are sealed in a bank vault. Now, Zephyr is a prolific writer. She's the author of the book Break 'em Up, Recovering Our Freedom from Big Ag, Big Tech, and Big Money. She published an article with Lena Khan 10 years ago in a Duke Law Journal. And perhaps one of my favorite pieces with K. Sabil Rahman, published by the Knight First Amendment Institute in 2020, reminds us that anti-monopoly regulations have historically also relied on an additional set of tools of public utility regulation, a lesson that is often forgotten as we try to squeeze everything into an antitrust box. Zephyr, we are delighted to have you on the show. Thanks so much for coming on.
Oh, are you kidding me? I'm thrilled to be here with two of my favorites on a show called The Slingshot. And I hate to break it to you, Wikipedia is, has some great features, but I was not really acting in high school or college. There are a few exceptions, but I can't believe they dug those up. But I am still doing theater. Having no longer involved in politics, I have rejoined a community theater that I've been involved with for a long time. The director is 99 years old. He's an amazing person. Fought in World War II. Started the theater when he was 60 years old and is full of big ideas for next summer. So I will be on stage next summer, and I'll see if I can get a VHS tape to record it.
Hey, Zephyr, I thought all politics was theater.
We'd fly out.
Oh no! Sorry, I shouldn't have laughed too quickly. It's all politics involves theater, but it is far more than theater. So there's some of it there, and it certainly doesn't hurt when you're going up against somebody like Andrew Cuomo to have a little experience walking out into a room with only 3 people there and still giving the show. At least when I first ran against him. So.
Now, let me just introduce, joining me and my partner in crime is Darren Bush, professor at University of Houston's Law School. You may not know that prior to becoming a professor, Darren was a trial attorney in the DOJ's Antitrust Division in the late 1990s. Darren, Happy New Year, and I bet you've got some buried VHS tapes as well. Any acting in your past life? You don't have to admit.
No, I don't have any acting, but I did play Sir Thomas More once. So there's a picture of me dressed as Sir Thomas More somewhere, and I do not look happy about it, although it was about as goth as I was at the time. So.
How do you do that without acting? You just came as yourself, Sir Thomas More? Is that?
I came as a very moody Sir Thomas More. So I think that's all I could pull off in high school. But
well, speaking of moody.
Yes. That's right. It's a nice segue. Today we're discussing 3 hot topics, and the first is Moody v. Netchoice and Netchoice v. Paxton, the Supreme Court cases challenging Florida and Texas laws regulating social media platforms. Second topic is going to be the Packers and Stockyards Act, and the third and final topic will be antitrust and corruption. But before we get to those hot topics, I wanted to ask Zephyr to reflect on her time at the New York AG and let us know of her proudest accomplishments.
I had a wonderful time there. I loved working for AG James, who, as you know, I ran against. It's the best job in the world to be Attorney General of New York, but was delighted to get a chance to work for her after her deserved excellent victory. I worked on a few different things that you might be interested in. One is I was very involved in drafting the proposed legislation for under 18-year-olds and child social media, trying to address the current crisis, really significant mental health crisis caused by social media use. And we can talk more about the legislation if we have time, but I think we did a really good job of crafting legislation that will be both Supreme Court proof, because the specter of the First Amendment really threatens this kind of legislation, but also really effective in reducing addiction. Second, I worked on proposed rules. The final rules aren't out yet, but hopefully soon, on price gouging. I sometimes think of price gouging as it's more than this, but it's like a poor man's antitrust.
Is it really a
price
thing? I think there's a columnist for the Washington Post who says it's a conspiracy theory on the left. I didn't even know
Yes.
price gouging was a thing. Go ahead.
Yes. Yeah, now the price gouging laws are, they speak to something very fundamental, objection to unfair prices. They're wildly popular and for good reason. And New York has a really wonderful price gouging law that prohibits excessive prices in the case of an abnormal market disruption. That's pretty standard. What's different about New York's law is that it explicitly goes up the supply chain and reaches not just the seller, but anybody in the supply chain for essential goods and services that are sold in New York State. So we put out, we did a rulemaking, and thank you, Hal, for your comments to that rulemaking. And the proposed rules clarify, they do some real housekeeping that's essential. They clarify that 10%, which is pretty standard across states, is the price increase that presumptively creates a concern about price gouging. You can defend against it by showing that your costs justified that. Interestingly, for our antitrust listeners, we looked at the evidence and the comments provided by several folks, including Hal, and the proposed rule notes that corporations with large market shares shouldn't increase their profit margins at all during abnormal market disruptions. So if you have a 30% market share, for instance, that creates a presumption of unfair leverage and the power to drive market-wide changes. And so we think that is an important part of the rulemaking. I should no longer say we, now that I'm out of the office. And then we also address dynamic pricing, because I think the price we've seen through the disruptions caused by COVID and the Russian invasion of Ukraine, how big companies are taking advantage of these disruptions to unfairly increase prices. But in enforcing price gouging laws, it's really important to address the fact that we're also seeing increasing dynamic pricing and personalized pricing, both of which make it harder to enforce. Because if you sort of take a standard model from 1970 and say, oh, the price of my ketchup went up 20% because there was a snowstorm. Well, what if your ketchup and your ketchup and your ketchup and your ketchup all cost something different, and also the price of ketchup is changing hundreds of times during the day? So we addressed that. I also worked on some cases. You may have seen that, speaking of price gouging, Tyson refused to comply with a subpoena when the office was investigating whether Tyson, in fact, increased meat prices, selling to supermarkets in violation of the of New York's price gouging law. They fought it with nails. They fought it and lost. So Tyson does have to turn over. Basically, Tyson didn't want to share what it was charging supermarkets and its own costs, which would be essential. So, yeah, it was a really interesting time. Related to something I know we're going to talk about later. I also saw just how important, how much cost matters, frankly. How much the cost, when you're sitting around thinking about, like, did somebody break the law? That's question one. And I know we're going to talk about this later, but in a lot of these cases, consumer antitrust and others, enforcers have to think about cost and have to think about expert cost. And that was something I'd heard about, but it was a real eye-opener.
Got it.
So I like the idea of dynamic pricing in the ketchup example, because the basic gist is the more dynamic the pricing, the harder it is for the enforcement agencies to catch up.
Oh,
So,
Yeah, we went
uh,
there.
but you see the puzzle here, right? You see the way in which, there's yes, I take your point. There's a lot of economists that don't like that don't believe in price gouging, and they get really mad about it.
Oh, yeah.
that's because price discrimination under a consumer welfare theory is an efficient thing, so they just love it.
Yeah.
They're just
Let's
responding
talk-
to demand shifts. But Darren, why don't you take us into the first topic so we can move things along?
Yeah. So let's talk about Netchoice v. Paxton, and
Yeah.
the by way of background, the Florida and Texas, the two very red states, passed laws in 2021 to limit power of the largest social media companies to moderate and curate speech on their platforms and require the companies to disclose certain information to the public. Netchoice, a lobbying group for Google and Facebook, appealed the laws under the First Amendment. The Supreme Court granted cert in both cases. Zephyr, why is this an important case for anti-monopoly folks to be following?
Oh, I think I'm so glad to talk about this, because I think this is such a critical case, and I understand why many of my friends are on the opposite side here, but I just think this is a wake up and look at the implications case. So, what's going on here? It's not just that these are red states. This is Ron DeSantis and Paxton. Paxton, who has corruption problems we don't have time to go into, is a dangerous demagogue. DeSantis, demagogic, don't trust him as far as I can throw him. So these are not my friends, right? And I don't actually think the laws they passed were particularly well crafted. I think they're really problematic in some ways. For instance, the Florida law, which bans any restriction on candidate talk on social media platforms, doesn't do anything with bots. So this is just badly written, because you can easily imagine how you basically just add the word Joe Biden or Donald Trump to anything you want to say, and then you can't, then it spams the platform. It's not going to be a fun platform to be on. So why am I so worked up about this and considering writing an amicus brief on behalf of two of the politicians that I like least in America? It's because at heart, this is about state power to do two things that are really important. One is regulate the internet, and two is use non-discrimination laws. So at heart, these are non-discrimination laws that forbid the platforms from treating different counterparties differently. Now, you'll see that a lot of the supporters of the big tech companies say we shouldn't think about them. They don't even talk about non-discrimination. They say these are like right of reply laws or must carry laws. And stop me depending on what level of weed you want to go into, but and there's precedent showing skepticism about the way the government can enforce its own speech biases in must carry laws and right of reply laws. And I think that skepticism is warranted, but we have to understand this is a different kind of law. This is a law like Munn versus Illinois. This is a law like the laws that many states have that forbid shopping malls from discriminating on the basis of viewpoint when pamphleteers come to share their views in shopping malls. Non-discrimination laws, and both Darren and Hal, I know you'll have more examples as I'm starting to build and work on these issues. Non-discrimination laws have always been really essential and tied at the hip to antitrust laws. The first federal antitrust movement was non-discrimination. It was requiring grain elevators to treat all commerce similarly. The second was the Sherman Act. And so if we're thinking about tools to take on concentrations of power and abuses of that, non-discrimination is an essential antitrust tool. And upholding state power to pass non-discrimination laws is critical. So if the Supreme Court accepts the Netchoice, and whenever you hear Netchoice, think the lobbying arm that's trying to get rid of all child social media laws, think YouTube, think Instagram, think Meta. What if the Supreme Court accepts what Netchoice is saying, even a narrow vision, which is, hey, the First Amendment protects, it sounds intuitively right when you first hear, okay, the First Amendment protects our right to engage in content discrimination. Like as a sentence, you're like, oh yeah, that sounds right. That sounds right. But when you think about what that rule means, content discrimination is not the limits of what constitutes content discrimination is effectively the same as viewpoint discriminatory treatment. So what shopping malls do when they say, oh, we will allow these pro-war people in, but not these anti-war, vice versa, that's a form of content discrimination. And it is good and right that the Supreme Court has previously upheld the power to pass non-discrimination laws, which are so superior to right of reply laws in their distance from a fear of government intervention. This isn't the government saying what you should say. This is the government saying you cannot discriminate on the basis of viewpoint. So
I want to go back. I want to go back to a second and piggyback on that. But before I do that, I have to give this disclaimer that Zephyr's views, Hal's views, and my views do not represent the great state of Texas, my employer. And I also want to reiterate the fact that I'm not sure if I have tenure or not, given last year. So in the legislation. So I just want to make that exculpatory language clear. You're right that there's a lot of history of the antitrust and non-discrimination. In fact, one of my pet peeves is when we talk about new platforms like social media, and we talk about we've had these battles in open access, right? People think of essential facilities as a remedy, but it's really a theory of harm. And open access is the remedy. And so we've had that in electricity, natural gas. We've had it in multiple different areas. Yeah. And so why isn't that sort of what's so special about the online platforms that it does those old concepts, those well-worn concepts don't translate well?
Yeah, I mean, I think they do translate, but I think that there are concerns and features of platforms that make it harder. In some way, one way to think about this is an online platform more like a newspaper or like a pick your utility. And people's intuitive answer is going to be newspaper because the thing it is carrying is text or content. But then we're like, okay, no, but in communications, we've actually always had non-discrimination as well, right? But there's still a deep intuitive connection between the kind of thing, the kind of discrimination that Facebook is doing. I understand why people have this intuition that it feels like it feels closer to what a newspaper is doing. I think that intuition is wrong. I think you're right about the history. But I want to even step it one farther than you, Darren. I want to say that the power to pass non-discrimination laws, and this is important, and it's where I sort of differ with the way that Texas has approached this, is I don't think the power to pass non-discrimination laws requires a intermediate determination that industry is a public utility. In this case, Texas did make that determination, but I don't think that as a constitutional matter, we should require that. I think we should generally say, if there is an industry infected with the public interest, the state has the power to pass these laws some of them are going to be good, some of them are going to be bad. And maybe this is where I'm resisting it, is I don't want people to think that they have to endorse these laws to recognize how important it is to oppose net choice. And a lot of the amicus are focused on how bad these laws are. And like, fine, go argue that in the Texas legislature. I don't think that, but what you don't want to do is create a First Amendment strict scrutiny rule every time content moderation is involved, because then you're just talking about the internet. I mean, this is what all companies do on the internet, is engage in some level of picking and choosing. And what I think it's critical for the state to retain the power to pass non-discrimination laws of all kinds. Non-discrimination laws based on, protected classes, sure, but also non-discrimination laws based on viewpoint. And so that we should recognize that it's good that some cities have rules that are sort of non-discrimination laws, that you can't be fired based on your viewpoint if you're a private employer in that city. That doesn't mean that you think your city has to have that rule. It's an essential power of the state to use this tool. And this is one of the tools that we have always used to deal with real problems of concentrated power. We don't have to separately decide whether it's utility. So there's kind of a sideshow argument in the net choice cases, which is some people say it is utility, some people say it isn't. It doesn't have features of utility. I think that's a total sideshow. The question is, do states have the power to do that? And if they don't, we're just starting to regulate the internet. We just sat on our hands for 20 years, right? We did more than sit on our hands, right? We started with a 1996 deregulatory approach. We're going to regulate the internet less than anything else, right?
Right.
And then we're just starting. And at this moment, to tie all the states' hands and say, oh, you're content regulating? Therefore, strict scrutiny. It's just the wrong way to think about it. The right way to think about it is, do states have the power to pass non-discrimination laws? And the answer just has to be yes. Now, to get a little into the weeds, Texas does have some exceptions for its own non-discrimination rule. And Texas's rule is you can't discriminate on the basis of the viewpoint of the user, either as expressed in a post or expressed offline. But it has some exceptions. And I think those exceptions, I'm trying to think through this right now, and I'd be interested in your thoughts. I think those exceptions should be strictly scrutinized. And I think they will probably withstand strict scrutiny, but that you don't want to have an exception like, but any referral from the Sierra Club, we treat it differently, because that would
Right.
that clearly creates the risk of viewpoint or content, high level of viewpoint discrimination. And in this case, it's Child Protective Service Agency, so I think it may withstand it. But the way that a lot of the net choice supporters are looking at it is they're saying, because there are exceptions, these are not viewpoint neutral. And I think, no, the heart and soul of this is non-discrimination. And I really think that those of us who care about the concentrated power need this. There's a reason that non-discrimination is part of a lot of the federal bills, is part of the child safety bills, is part of Packers and Stockyards, which we'll get to later.
You know where non-discrimination is? Maybe you haven't followed, but it's where I cut my teeth growing up. But the non-discrimination bills in the Cable Act, Section 616,
right?
A
Yeah.
whole bunch of cases. I testified in NFL v. Comcast, tennis v. Comcast, Masson v. Comcast. I joked that I was no longer invited to the Comcast Hanukkah parties after this run, but we were successful and made it up to the Comcast. Finally figured out they needed to appeal these losses up to the DC Circuit.
Yeah.
And Justice Kavanaugh at the time basically read the act to require antitrust standards and overturn victory. So anyway, just a fun aside there. You mentioned some of the.
It's not an aside though, because here's the thing that I think is important for public utility, and I have the sort of view on this case, but I do think it's the simple vision is utility regulation and anti-monopoly, they have to come together. Is that if net choice wins, we freeze public utility regulation in time. Because the core of their argument is, if you are discriminating, Then you get another, which they use if you are engaging in content moderation. So just replace those words. If you're engaging in content moderation, you can't pass laws that ban that content moderation. So there's a fundamental circularity there. So Skype, for instance, currently not treated as a public utility. It has the capacity and does in fact censor content. I think it's good that we have non-discrimination laws for to the telephone services and don't allow telephone services to discriminate. The logic of Netchoice would say, because Skype already engages in content moderation, therefore we can't pass non-discrimination laws. There's just a deep circularity, and it's a very deadly circularity. And I don't think that most of the amici, I mean, I think the corporate amici have thought about it. I think the Cato Institute has thought about it, but I don't think the sort of left-leaning amici have really proposed. And I've been hunting. I have no great love for these laws. I'm not going to cry crocodile tears about these laws getting, getting overturned in their legislatures. But I haven't seen a limiting principle that doesn't actually end public utility regulation going forward.
Yeah. Well, what about the American Innovation and Choice Online Act?
I know.
What would happen to it? What would happen to it with a Netchoice win?
Yeah, with the Netchoice win, I believe that a Netchoice win would get rid of the non-discrimination parts of the ACOA, because it would say, because the real structure of the argument is if content moderation, then platform speaking gets First Amendment strict scrutiny for any. And you would need to show compelling interest and narrow tailoring. And as you know, strict scrutiny, First Amendment realm, is treated as strict in theory and fatal in fact. So I think ACOA is gone. The Save Local Journalism Act, is that its current name? The Klobuchar-Jayapal Act also has a non-discrimination provision. You can't treat different newspapers differently, right? It's very similar. And that would be subject to strict scrutiny and gone. The bill that I worked on in New York, I hope it wouldn't be gone, but it is effectively a non-discrimination bill. And then, which is to say that you can't treat any child differently than another. You cannot use their PII, can't use their personal identifying information to deliver content. So you cannot discriminate on the basis of of who they are in the content that you deliver. And then when we're thinking about regulating AI, I think non-discrimination is going to be really important. So it's it would both freeze public utility regulation in space, but also freeze real innovation in regulation at a time where, look, I don't want the state dictating what we think. Right? I share the deep concern about state dictation of what we think. This ain't it.
Yes.
And the other thing I think is that what's really driving a lot of my liberal friends on this is they're scared of Paxton, and they're scared that Paxton and DeSantis aren't serious about this as a non-discrimination law, that they will enforce the law in a discriminatory way. And they are right to be scared about that, and we have to be on top of that and ready to sue if they do. But the law itself as written isn't the problem. It's Paxton and DeSantis that are the problem.
Got it. Well, look, I think we should probably move on to our second topic. It's like our second child. They're all equally important to me to give some attention to them as well. So let's move to the Packers and Stockyard Act, if that's okay.
Yeah.
And for the uninitiated, the purpose of the act was to, quote, regulate commerce in livestock produce, dairy products, poultry products and eggs, and for other purposes. And it prohibited packers from, among other things, engaging in unfair and deceptive practices, manipulating prices, and creating a monopoly. The law passed in 1921. And Zephyr, my first question for you is, why is it still relevant 103 years later, assuming I did the math correctly there?
Yeah, well, do you know any farmers? I mean, I know you do.
Yes.
So I know both of you do, but I know, Hal, you have certainly encountered this issue. I don't have the numbers at my fingertips, but clearly the concentration problem of 1920 has not gone away. It's really significant. And we 4-5 big Packers farmers are deeply beholden to them. They're continuing to get less on the dollar. Some wins occasionally if you can find a smoking gun, but the fundamental structure of power in livestock and the necessary geographical constraints of packing, this is something that has to be. You can't send your you can't send your meat to 10 states away to get it processed, let alone 1 state away in most places. Creates just a structural issue that long predates the antitrust, the Reagan antitrust revolution. So it's still needed, and it still hasn't been enforced.
So I'd be remiss if I didn't mention my co-author Peter Carstenson's article, "The Packers and Stockyards Act: An Historical Failure to Date." And
Yep.
he claims part of that failure is the courts have done much to hamstring private plaintiffs, which is what your complaint, I think, is, which we've seen in antitrust as well. So I suppose the question is, the more you have these sort of specialized antitrust enforcement laws, do you really get away from the limitations of antitrust by doing that? Do you exacerbate the problem? I mean, so I'm asking you a bunch of compound questions, but we're not under deposition, so you can't.
If we're under deposition, I defer to Hal. He's going to take it all.
Badly, I'm being deposed on Friday. But yes, go ahead, Zephyr. You take that compound.
Yeah. So let me drill it down a little bit deeper. Yeah. So,
before you do, Darren, can I just, because you said something that I want to descriptively lay out. It's a great article that Carstensen wrote. It's really important. There's 2 really bad cases that effectively import bad antitrust law into the Packers and Stockyards Act, and they do it in the context of private plaintiffs. This is not Supreme Court level. There's real disagreement at the district level, if not at the circuit level. So it's the precedent is bad, but it's not Supreme Court bad, if that makes sense. So,
right.
I'm sensing a pattern here, though, Zephyr, of folks importing antitrust standards into law that was meant to fill a gap in enforcement from antitrust. Yeah. I think this could be a topic of an article. Maybe your next piece. You could weave in. Well,
I wanted to talk about Packers and Stockyards because I kind of, frankly, because I'm like, should I write about it? Peter's article is great. There's a nice note that just came out. But maybe you've given me the framing, because there's something that keeps returning me to Packers and Stockyards, and it's not just hanging out with farmers. It is a sense of one. There's a non-discrimination provision in there, which I think is really essential. So it shows how a federal, the federal legislature understood that constraining Packers' power included unfair practices and included non-discrimination, but required a special focus on all the tricky ways that the Packers could get around federal antitrust law. Like, that's the reason to have the special agency. And then in these cases, the courts decide, well, there might be some efficiencies here. Or in Wheeler, which is this terrible 2009 case, you have to prove harm to competition. This is a case, it's a remarkable case. It's sort of like the blast radius of the antitrust revolution. I went way beyond where it was supposed to. Because in Wheeler, they're not even trying to do statutory interpretation. They're not serious about, they're just saying this is the way we think the law should be. the court is not serious about finding a statutory or historical hook or a textual hook for finding that there needs to be a harm to competition when somebody is unfairly rejected by a packer, like a recent case where this woman joins an association. I mean, you guys have far more experience in this field than I do. I come from democracy, but you know why I'm here. So she joins an association and therefore gets, cut off from selling, and she sues, unfair treatment. And the court says, yeah, but you have to show harm to competition, not just harm to you. This is crazy, because this is, of course, exactly, not exactly, it is a more egregious example even than what they were thinking about in 21. So I just wanted to set that table, Darren, before we get to your question, because you're asking, like, should we have specialized agencies? And frankly, I have two minds this, and I'd be really interested in your views. There's this effort by big tech to say, let's have a specialized agency, and but they're effectively trying to remove a jurisdiction from the FTC and the DOJ because they know they'll enforce the law, right? That's really dangerous. But when it is clearly supplementary and designed to be looking for all the ways in which industry may be unique, and unique industry features allow for unique forms of unfairness and unique forms of abuse, I do actually tend to think it's appropriate. But this Vilsack is such a profound disappointment, because he had the opportunity here to come out with a clear rule, federal rulemaking on Packers and Stockyards Act based on the text of the act, the history of the act, the authority of the act, and the purpose of the act, to say there is no harm to competition requirement. And those private cases we talked about, yeah, that's a different ballgame. So he had the opportunity to shift and win, and has not done so. And it's an extraordinary missed opportunity, and it's really bad for farming and health and our food ecosystem. And I'm focused on it because I think there's still a chance for him to turn around. And I know we've been burned twice by Vilsack, but come on, he's got to get embarrassed at some point.
No,
so this might go ahead.
But you did answer my question. So,
what do you think? What do you think about the?
You asking me how?
Yeah, I'm asking you.
Oh, well, again, my views are not the views of the great state of Texas, yes. And I'm not sure if I'm tenured anymore. I really wish I were more hopeful about, I think there's been some great strides in antitrust in the last couple of years, which everyone the Wall Street Journal has written 3,000 times that it's hidden. But as far as Congress doing anything, I am not hopeful, and I think it's more like incremental steps, and anything that would be a giant leap forward, it, has risk of being rolled back, quite frankly, depending on the election. So I guess I think of it, the reason it's such a disappointment is because it's clear where Biden has been on this, not broadly. Biden has broadly been good. I thought Vilsack was going to be so embarrassed by what happened in 2010 that he would say, yeah. Okay, I gotta do it right.
Compensate.
It's the opposite.
Yes.
I gotta compensate. Yeah. It's like, okay, yes. So
right. So then I had a question for you. You may have preempted it, but Food and Water Watch and 13 other organizations submitted comments on the proposed rule last year.
Yeah.
Emphasizing that farmers deserve meaningful protections under the act, not just more information about likely corporate abuse, which is, I guess, as far as the Biden administration is willing to go. And they claim that the Biden administration, quote, capitulated to big ag, right? And those are pretty harsh words. Do you agree with their characterization, capitulation?
Well, it doesn't look good.
Okay.
I mean, like, I don't know enough about what's happening internally to sort of say anything but res ipsa loquitur, but I think the most generous reading, okay, no, maybe I do know a little. This is, the most generous reading is that they're scared of losing. And I don't think that's a generous reading, to be clear. I don't, that's not a compliment, right? And by that, I mean, they're scared of putting out a rule that says no harm to competition is required, clearly supported by the text. The rule would be immediately challenged, and it would be. And they shouldn't lose, but they might lose. And they're not wrong on that, right? Like that's just, look at the Supreme Court, they might lose.
Isn't that the nature, like, we were talking about Vilsack and rulemaking, there's always someone threatening, like the FTC about its statutory authority. There's always someone threatening, oh my gosh, don't promulgate a non-compete rule because major questions doctrine. It's
right.
Like if you worry about rain all the time and carry an umbrella on those sunny days, and you'll be less likely to go outside, right? So.
Absolutely, and you build strength and you build confidence and you build. I mean, these are farmers are so demoralized by this, so demoralized by decades, but a moment of the administration acting and saying we are not going to allow this mafioso kind of behavior anymore. Like, you have the right to be treated fairly. I mean, this is what connects Packer and Stockyards and price gouging, is that there is a resurgent understanding that fairness is actually highly relevant to a thriving economy. Like, we need and people will respond to the fairness, and the stories that the farmers have are really powerful. I take that to the Supreme Court. I don't know what's going to happen, sure, but I think you have a chance. I think you have a chance of winning. This Supreme Court is very problematic on a lot of things, but it's also kind of weird. Yeah. And I think there are
showing sympathies to workers all of a sudden.
So there's weird alignments. It's like there's a chance. There's a strong argument. It's the correct argument that a no harm to competition rule should win. And it doesn't belong in the antitrust category. It belongs in the Packer and Stockyard category. So I just think it's embarrassing not to go forward with that fight. And okay, so let's say you lose that fight. The next day you pass a law in Congress because people believe in this law. But if you don't have the fight, it's a very confusing law to pass. I mean, what was that law that Obama signed like the first day in office or whatever, Lilly Ledbetter? You lose, the next day you pass a law. That shows real power and energy. It's an opportunity, and I don't know if they lose.
It's a good strategy. Let's we have a third child here, so let's go to this third topic. Show her some love too. Antitrust and corruption. And Zephyr, you wrote a piece in 2018 called "The Problem of Monopolies and Corporate Public Corruption," in which you explain how antitrust can be used to fight corruption. Now, can you just explain to our listeners the nexus between monopolies and corruption? It might be obvious to some of us, but it might not be so obvious for others. And, I thought the Chicago school settled this debate. I explained a long time ago. I got this from your piece, of course, and you have to insert my sarcasm emoji here, that once a company becomes a monopolist, they have lost their incentives to expend resources on obtaining the aid of government and fending off competitors. Maybe you have a different take. Who knows?
Yeah, it's sort of, were they dupes or cons, right? It's such a remarkable, it's one of my favorite questions for all neoliberals, like dupe or a con, because there's some real dupes who really believe.
Okay.
Yeah. Yes. And sometimes it's just, it pays well to be a dupe. So,
yes.
But come on, like the sort of incapacity of the Chicago School to understand human nature is breathtaking. And I just wanted to end with this. I am making an obvious point, but it's an important one. As I said before, I spent most of my legal career in anti-corruption, election law, voting rights, a lot of time trying to stop what ended up in Citizens United. And I still am an anti-corruption. And I want to say that because I think it's important to understand that 1960s shift, 1970s shift was in the Chicago school, but it was broader. That in political science, there was a great failure too. And in political science, there was this sort of brain splitting of the brain to study that we study what is the formal power in the United States. And econ studies econ, and just a loss of a really basic Aristotelian understanding of corruption. Like if you have power and you use it for over others, and you use it for selfish ends instead of public ends, that's corruption. This is the oldest, this is thousands of years old understanding. And in splitting our brains, they also split our energies. So I say it because one, antitrust lawyers are the only group, everybody wants to say, what I do is really about democracy. Antitrust lawyers are the only group of people I've ever met who are like, no, we're not doing anything that important, right? Stay away. But in this case, it is more true than any other area. We are really facing, and this connects to Netchoice, we are facing a democratic crisis because of concentration in ag, sure, but we are especially facing a democratic crisis because of concentration in tech, in AI, in existing platforms. We have never in human history allowed a handful of people to control all the arteries of communication. And I just think we have to call it what it is. When they're doing that in a self-serving way, that's a corrupt system. It's not just them being corrupted when they're passing cash. And that is why I am, continuing to learn the tools of the trade, because the antitrust tools, the non-discrimination tools, the Sherman Act tools, these are democratic tools, and they are as important as election law tools.
Let's talk about some of the poisons, and then we'll talk to you about the remedy. So Tim Wu wrote a piece where he talked about antitrust and corruption, and he suggested that the key to scrutiny of corrupt and deceptive political practices was the repeal of Noor-Pennington.
Mm-hmm.
One possibility. Another possibility is something I was pondering. I wrote on a snarky blog post for the Sling. For government attorneys, a win involves a settlement. Does not matter the degree. A consent decree is a win for budgetary purposes. A successful trial is a win. And if the parties abandon the transaction, that's a win. While government attorneys are not paid well, they can take solace in doing the people's work or eventually leave to do work on a better paying side. So and that we see people going in and out of government, and it becomes the case that people who we can now go to the ABA antitrust spring meeting and say, I was with the government and therefore I'm pro-enforcement.
I know.
So does Tim Wu's suggestion about banning, eliminating Noor-Pennington make sense? And two, is there a way we could perhaps break that revolving door?
Yeah, I like Tim's idea. I mean, sure. And I have to go back and read his article. I know you sent it to me before this talk, and I didn't have time. That was a real cough. That wasn't a cough to read it.
But Darren, why don't you lay out what's Tim's theory? How does Noor-Pennington foster a corrupt environment? And what's the mechanism?
Well, I mean, the idea is that. Go ahead.
Or Darren, Zephyr, you can go.
Yeah.
Zephyr, you do it.
Well, the idea is that you get antitrust immunity if you're sort of scheming to pass laws. And it's, as most of the modern corporate protection laws, grounded in a First Amendment theory, the First Amendment has just gone, the First Amendment has become the deregulatory tool. And this is also a way in which the anti-corruption, I want to sort of give a warning from anti-corruption world. The First Amendment in Noor-Pennington, so Tim's saying it's always on shaky grounds, I believe, right? And we should repeal it, yes, but we have a Supreme Court problem. Is that antitrust has operated despite it's been deregulatory on other terms. I guess that's the way to put it. The deregulatory move in antitrust has been grounded in economic theory, not the First Amendment. That's not true for Norr Pennington. But I think what we see with Netchoice and other challenges is we are going to see the already destructive and I think indefensible use of the First Amendment as a deregulatory tool for corporate power. It's going to be the First Amendment versus antitrust is going to be where a lot of the big fights are. It's not just Chicago School, it's Chicago School plus First Amendment. Sorry, I went way beyond Tim's article. Darren, sorry.
Hey, no worries. I mean, we used to talk in public utility regulation about capture, right?
Right.
And it's good to talk about antitrust in terms of capture theory because it's sort of everyone believes the same, sort of consumer welfare religion. And so it's harder to post or describe a remedy to that larger problem.
Don't you think that's changing? I mean, granted, it's hard. There's a combination of people who are, so smart and so well trained, and they feel like the ideology is tied up in their training and they can't discard the ideology, although theoretically they could. There's nothing necessarily ideological about their technical skills, right? And then there's people who it's, to very much date myself with a Big Chill reference, you can, rationalizations are more important than sex because you can go a day without sex, but you can't go a day without rationalizations, right? The need to rationalize your last 5 years, let alone your last 30, is the most fundamental human need. So that you have argued else how makes it just so hard for you to change. But it is starting to change, don't you think?
It's hard to say. I mean, there's an article, I wish I could remember the author, who was talking about the European Union and whether they were actually moving away from consumer welfare theory or not, and was trying to use an empirical model to demonstrate that really their cases are mostly based on consumer welfare.
Yeah.
And so so if Europe's not moving, we sure as heck aren't. And I think that creates a whole host of problems.
So one thing I've really, the direction that I would like to go, and it's in part for political reasons, and I mean political in the sense of like being able to sell it, is I like the business torts model. Like thinking about a lot of antitrust as non-discrimination in business torts. And the reason I like business torts is to make it more like law, basically. And that antitrust has so much mysticism around it. And the more we can get to say, you just don't, and so that means there are no defenses, right? Or the defenses are failing firm, in the merger context. There's just the very, very limited defenses, as opposed to this model we're in now. And this is what we see in the Wheeler and Packers and Stockyards is, like if you import the harm to competition model, it's like, oh, it's true that you bribed the senator to, traditional bribery law. It's true that you bribed the senator, but was there a harm to democracy? Right? Like there's some things. So to even have gotten to that place where that's the way that we structure arguments, and that is the way we structure arguments right now in Packers and Stockyards, is like, it's true that you were unfairly discriminated against, but was competition harmed? This, it's nonsense. And that if we could have a business torts model, something that is a significant break, as because I spent a lot of time before I went to the AG's office, like trying to rewrite Section 2, like if we could get a real rewrite of Section 2, but we're starting with such tainted, I don't know. But at the same time, I don't want to give up on the courts. I'm not giving up on the courts. As you can see, I'm all of the above, I guess, on strategy. But I think in explaining to people, I've moved more towards business torts. Does that make sense to you guys?
Yeah, I was going to ask Hal because Hal Judge recently called Hal a hired gun. Not Hal.
Yes, Hal.
All economists hired guns, and so I was going to ask Hal how he kind of felt about that. So, whether business torts.
Now you are my favorite hired gun.
Oh, thanks. I appreciate that.
You're my
beer, I'll
favorite
explain to
too,
you
but
maybe how hired guns on the plaintiff side are a little different, but
Yes.
don't want to tax anyone here. But yeah,
Although
you're talking
what
about
I mean,
proving harm. Oh, go ahead.
what I learned, and you knew this, but I learned, not with reference to a particular case, to be clear, at the AG's office, is that there is a strategic interest in hiring people who've worked for defendants. Because if you hire somebody who worked for a defendant, then the judge is more likely to think, oh, they're even-handed. They're not just for one side, which means they cost more and they're far less likely to be useful on aggressive theories of harm. Does that make sense, Darren?
Yeah,
well, right, but how? I mean, you're awesome, and you do a lot of hardcore stuff, but I would imagine there's the plaintiffs aren't charging the same amounts that are paying the same amounts that defendants are, and so do you kind of feel like there's this outgunning that's happening with you?
Well, I mean, I'm typically going up against, three folks who are kind of willing to say anything. And yes, their bill rates are probably multiple of mine. But my thing is just there's an asymmetry in the risks. They face no downside and they can basically just say anything. But anyway, we don't want this to devolve into a woe is hell thing. Let's just talk about something uplifting for
but the asymmetry, I think, is really important. And I alluded to this earlier, but I think one of the biggest things that I learned is just how much experts cost. And how much expert cost, $8.50 an hour, you add up the hours, $5 million in the FTC suit. If we are going to have and I think we need to, states, not just the federal government, really engaging on states, Minnesota's passing new laws, right? And enforcing new laws. The focus has to be on laws that do not cost $5 million to enforce per case. That is not law to have a $5 million tax every time you want to bring a case, because that's what's going to cost you to bring the experts that can overpower their experts in something like in a tech case or whatever. It's really out of control. And I do think you see state enforcement across the board, understandably, doing a few big cases, but then a lot of small ones, because there is not and will not be the funding for the experts. And so one solution is find a whole lot of money for states that they don't already have. And the other solution is laws that don't require experts to fight about harm to competition.
Right. Proof of injury, right? Connecting the nexus, right? The nexus between the conduct and anti-competitive effects. You can see what that's done to my face and hair over the last 20 years. But anyway,
it's made you more handsome.
Might be a good place, Darren. That might be a good place to wrap it up. But Zephyr, did you have fun? That was the whole point of this thing, was to let you kind of show off your brilliance, and we just
no.
Our readers are going to enjoy it as much as we did.
I mostly just wanted to talk to you guys, so I achieved.
Well, it was great fun.
No, I had a great time. It was great to talk to you. And Darren, despite your gloominess, talking to brilliant people like you who just have this sort of deep well of knowledge to bring to bear to this really epical fight. Epical?
Yeah.
Is OC, not ICAL, epical. Epic and epical fight is.
I feel it's quixotic.
No, it's you can keep being gloomy as long as you keep showing up with your brilliance. And Hal, I always love talking to you. It's great to see you.
Well, thanks. Well, thanks for coming on, and have a great weekend. We'll see you guys.
See ya.